well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. You know, I was starting to feel like that old Paul Simon song, The Only Living Boy in New York. I was starting to feel like the only Second Amendment advocate, not a chacho this week. But no, I found another. Mark Walters, host of Armed American Radio. He's going to be with us here in a moment or two. We're going to talk about the oral arguments in Wolford versus Lopez at the Supreme Court yesterday. I know we talked about it quite a bit on yesterday's program, but I want to get Mark's thoughts on this as well, just, a second opinion. Also want to talk about what's going on in Virginia, where we had lobby day this week. We've also seen the permit to purchase bill, at least one version of a permit to purchase bill introduced. More bad bills on the way, and we are keeping our eyes on what's going on around the country, I promise. Just because I live in Virginia doesn't mean I'm focused exclusively on that state. So we have seen Governor Michelle Lujan Grisham in her State of the State address on Tuesday call for a ban on so-called assault weapons, more regulations for firearm dealers as well. So we're keeping our eyes on that. This is a 30-day, supposed to be a budget session in New Mexico, but they're going to try to ram through a gun ban bill in the next month in Santa Fe, New Mexico as well. And there are going to be more bad bills dropping around the country. With the Washington State, that bill that would ban the use of 3D printers, or would ban 3D printers if they can be used to print gun parts or firearms. And Rifle Act in Illinois is already being debated. This is another just absolutely atrocious bill aimed at the firearms industry. So there's a lot to be concerned about. On the pro-gun side, we're seeing some bills. I think the issue is, most red states have pretty good gun laws already. The states that have permitless carry. We got 29 of them. North Carolina legislature has passed permitless carry. It's vetoed by Governor Josh Stein. And the problem is there simply aren't enough votes to override the governor's veto in the House of Representatives, at least not on a day in which every legislator is present. So we have seen a vote to override the governor's veto delayed in South Carolina multiple times. Looks like it's been pushed back again. But we are keeping our eyes on what's going on in all 50 states of the union, and as well as what's going on in Washington, D.C., where, again, yesterday, Supreme Court heard oral arguments in Wolford versus Lopez. I predicted on the show yesterday, 6-3 decision striking down Hawaii's vampire rule. Let's see what Mark Walters has to say. Take a look and listen. Mark, how you doing, sir? It's good to see you again.
I'm doing wonderful. How you doing, Cam? Thanks for having me on today.
Absolutely. It's Wednesdays with Mark, almost as good as Wednesdays with Mark.
It's all good. Any day with Mark works. I like it.
Absolutely. Well, I'm glad we had you on today, because yesterday we had the oral arguments in Wolford versus Lopez. We've had to preview that if we had you on Monday, but now we can actually talk about what happened.
Yeah.
I got to say, I feel pretty good about this. I think we're looking at a 6-3 decision striking down Hawaii's vampire rule.
I'm going to get a little more aggressive.
Okay.
Okay. I texted you earlier telling you I had a prediction to make, and I think it might be a little bold, but you're very experienced in listening to oral arguments from SCOTUS, and it's impossible to judge from a line of questioning. Barrett's famous for this. Barrett will throw the devil's advocate questions out in cases where you already believe what her position will be from a gun rights perspective, et cetera. And you'll hear some of her questioning, and you'll think to yourself, ooh, that doesn't sound good. It's almost like she's taking the other side with this aggressive questioning. But then when you understand what she's trying to do and why she's doing it, it's usually in response to an attorney's answer that got cut off or something by one of the leftist judges, and she wants that person to be able to come back and finish or reiterate their point. Yeah. We watched Thomas do that yesterday expertly. We saw Alito do it. We saw Kavanaugh do it. And we certainly saw Roberts, which was people like to think Roberts is real wishy-washy. I've been guilty of that. But we can't forget, he's voted with us in all three major 2A cases, from Heller to McDonald to Bruin. Mm-hmm. And the Supreme Court, as you know, even this is where my prediction begins to come in. Keep this in mind. Even those justices who might disagree with a particular position or a particular case that they dissented in, even if they wrote that dissent, understand that to be precedent. Now, the outlier here from yesterday's questioning was clearly the DEI hire, Ketanji Brown. Ketanji Brown was coming at this from the full left. I can tell you right now how she's going to vote. She's clearly going to side with the unconstitutional position of the state of Hawaii.
Yeah.
However, I'm not convinced that Kagan and Sotomayor will do that because precedent is clear, not only in Bruin, but going back to Heller and even McDonald as well. And just because they're questioning is questioning the government on their positions does not necessarily mean that they might not side with that precedent. I wouldn't be shocked to see an 8-1 decision. It would not surprise me, but I think 6-3 is more reasonable, but 8-1 would not shock me.
I would be shocked at 8-1. I would be surprised, but pleasantly so at 7-2. Like I think of the three justices that you mentioned, I think you're absolutely right. Ketanji Brown Jackson is going to say, look, this isn't even a Second Amendment case. You know, she explicitly said the Second Amendment isn't implicated here, right? That wasn't a question. That was a statement yesterday.
Right. Yeah.
She thinks this is just a property rights case. And Justice Roberts, I think, skewered her for that by pointing out, you know, listen, we're talking about, you know, somebody who owns a gas station on the side of the road. You know, do you have the ability to walk up to that gas station? You know, is there expectation that you can go inside? Yes, there is. You know, pointing out, and Gorsuch pointed out, you know, property law or your property rights, you know, cannot conflict with somebody else's individual rights, right? You as a property owner have the right to say,
correct,
I don't want to allow concealed carry, or I don't want to allow firearms on my property. But in a nation in which the right to keep and bear arms is a real thing, right? The default should be you get to exercise that right. And it's the exception, not the rule, that you don't. Kagan was pretty quiet during the oral arguments yesterday, right? And Sotomayor, a lot of her questions, and maybe she was playing devil's advocate. I don't know. I kind of got this sense that she really does believe that Hawaii's culture, you know, should trump the national tradition of gun ownership. And that was obviously was an argument that Neil Cagill, the attorney representing Hawaii, was eager to exploit. I mean, he was basically making the same thing, that the spirit of aloha and, you know, 200 years, the independent kingdom of Hawaii never really allowed gun ownership. So why should we do this now? Right. And the reason is because you're not an independent kingdom anymore. You know, you are part of the United States of America. The U.S. Constitution applies. The Bill of Rights applies. And that means the Second Amendment is a real thing. So 7-2, I would be a little surprised if Kagan joined in. 8-1, I will bow down to you, man. I'll get all the credit in the world if that happens. And I'll be very happy to see it. But, you know,
I'm just being the eternal optimist here. I would love to see 9-0, and that's what it should be. This case should be a slam dunk. Yeah. Now, is 7-2, 6-3 a slam dunk? Hey, look, I'll take a win. A win is 1-0, okay? We see that in boring soccer games all the time. 3.5 hours of play, one score. That's a W. I'll take that victory. I'll take a 5-4. It will no doubt be 6-3. There's no question. 7-2 is more likely. The 8-1 is a long shot, but I would not be surprised. I mean, it won't shock me. It would surprise me, but it will not shock me because the Supreme Court has a history over many, many years of being very loath to really destroy their own precedent, even in cases where justices might not like the precedent. Look, we know Kagan and Sotomayor and Ketanji Brown don't like guns. We know that. But we also know that all three of them, including Ketanji Brown, understand what precedent at the court means. They know it's give or take. They know that, well, I should say not give or take, to be honest with you, depending on how we're viewing the case. But I think what's important is here we have to go back because you mentioned the property rights aspect of this case. That's critical to those viewers who might not understand. Hawaii's default position under the law is guns are banned everywhere on private property. The owner must make an exception. Now, I'm all for property rights, like you said. If you have a green pickup truck and I'm having a party and I don't want a green pickup truck in my driveway, you're not coming into my house if you drive your green pickup truck. That's my right to say that. But your green pickup truck, first off, the most important aspect here is my home isn't open to the public. A privately owned convenience store is. And that was what was getting to the crux of that law. Both Kavanaugh went at that. So even the liberal justices questioned that, but they seemed to side with the property owner being okay banning a constitutional right in a place open to the public.
Well, not even the property owner. They were okay with the government,
correct,
banning it, and then the property owner having to exclude themselves from that prohibition, right?
But they don't do that and can't do that under First Amendment protections. Fourth Amendment, the taking clause came up. This was a fascinating argument yesterday because of the property rights aspect of this. I listened to this and went back and reviewed it a few times. And on my show yesterday, I covered your piece and your analysis on it because it was so spot on. I believe in your analysis there. I think we might differ a little bit. I think 7-2 is more realistic. I would love it. I would love it to be 7-2. I would love to see Kagan or Sotomayor actually side with the court's own decades of precedent here regarding the Second Amendment, and whether they agree with Bruen or not, defer to that as precedent.
Yeah. Well, I mean,
I 4 years under their belt now.
I think if any of the three justices are going to do it, I think it's going to be Elena Kagan. You know,
Yeah.
She seems to be the most, I think the most fair-minded in that regard, right? In terms of looking at precedent, in terms of looking at what the law is. She wrote the unanimous decision in Smith and Wesson versus Mexico, and I pointed out AR-15 is the most popular rifle in the country, right? I mean, so I think Kagan would be the one. But I'm also
let me ask you this though before we move.
Yeah.
As far as writing a dissent, I thought yesterday that based on the questioning I heard, and again, this is just speculation, but years of speculating on these cases. I'm not shocked to see Ketanji Brown write the dissent in this case, and I hope they do that because her basis for the dissent is so off base that it will be shredded, absolutely shredded when it's read and the final decision in the majority is written. So I would love to see that because her position was so off base.
Yeah.
Going back to King Kamehameha in 1833, for crying out loud. And did you notice, I'm sure you did, the state relying, trying to skirt past Bruen with the history and tradition by saying it's Hawaii's tradition since 1833. They're trying to throw those words in to try to skirt Bruen and what the history and tradition in context in that decision actually means. So fun stuff to watch. I can't wait to see it. It's a win for us. We're going to win it.
I mean, I do think you'll see a dissent from Ketanji Brown Jackson. You might even see two, right? I mean, Sotomayor might write her own separate dissent because they seem to agree that Hawaii's law should be upheld, but for very different reasons, right? So I wouldn't be surprised if we actually see two different dissents. But
they will say that this is property rights, as you said, not a Second Amendment case. That's the direction they're going to use in a dissent. You can mark that one down. Yep,
absolutely. And then I think Sotomayor may talk again about what does this tradition look like? What, do we have to look at a national tradition? We look at these regional traditions, maybe just the tradition of a state. Again, I hope she doesn't embarrass herself by writing a dissent that focuses.
You can't help it. They can't help it. They're going to, and I'm looking forward to reading it.
But I'm curious to get your informed speculation about what do you think the majority opinion is going to look like. So top level, strike down the vampire rule. But some of the conversation, a lot of the debate actually yesterday was over the level of generality that has to be used. When you're looking at these historical analogs, how specific do you have to get, right? Neil Kyle argued that the laws that they proposed were, three laws. First of all, does that represent a national tradition? And then the laws in question primarily dealt with anti-poaching laws, right? They were laws about not bringing your gun onto enclosed land or onto improved land. Alan Beck even pointed out at least one of those laws had an exception for bringing a gun for the purposes of self-defense, which to me, all of a sudden now that's completely different, right? So you got that issue, like how specific do these historic laws have to be? And then the other issue was the third law that the state of Hawaii cited, the 1865 Louisiana law, part of the Black Codes. There was this really interesting back and forth about whether or not a law that is clearly unconstitutional today, and as the government's attorney argued, was unconstitutional from the get-go, should that be considered a part of that national tradition of gun ownership, or should that be an outlier? The government's position was any law that's unconstitutional is by necessity an outlier, right? Because they're not a part of our laws. They violate the Constitution. Do you think the court is going to get into that issue, get into these issues, which would have implications far beyond Wolford, right? I mean, we're looking at any number of sensitive places. Fourth Circuit yesterday upheld every one of Maryland's gun-free zones, with the exception of the vampire rule. And they used the dissenting judge in that decision pointed out, they used just a couple of analogs in some cases. In some cases, it was private railroad rules when they couldn't find an actual law. So clearly, I think there's a need for the court to say, all right, listen, here's what a national tradition looks like. Do you think we get that from the court in Wolford?
That's a great question. I don't know. And here's why. They're going to have to address it, but to what extent do they address it? is what's going to be the key here, because that has implications outside the bounds of the Wolford Lopez case.
Mm-hmm.
And, you know, if you go back to Scalia's decision in Heller, if we go back and look at that historically, gosh, wouldn't we have loved to have seen Heller or Scalia in the Heller majority opinion actually come outside the bounds? But he was notorious for not doing that. He stayed within the scope of that case itself.
Yeah.
But he touched on it, almost alluding to, we need to have another case on this. I don't know how they do that in this case. I really don't have a clue how that's going to happen. And forgive me for not remembering the justice. I believe it was Kavanaugh who addressed that very issue. And that's why when I held my three fingers up, you're talking about the three cases. It was pointed out by that justice, I believe it was Kavanaugh, that those in fact under Bruen are considered outliers, which Bruen points to, not those three, but the outlier itself, and not being 3 states out of 13 or 18 or 20 states at the time, whatever time frame we're referencing here, as being a national historic tradition within the scope of Bruen. So how that's addressed, I don't know. And that's a really interesting way to look at it. I really hadn't put that much thought into it. I was looking more at the dissent under the assumption that we're going to win this thing hands down.
Yeah. Well, you're right. It was Kavanaugh. And it was interesting that Kavanaugh talked about that, right? Because he said this has to be a national tradition, has to be broad, right? He said it has to be deeply established. So he said it can't be just a couple of states, can't be just from one particular time period, or laws are only on the books for a short period of time, right? A national tradition means that this was something that you saw across the country, right? In 1791, that would have meant the original 13 colonies, and but 2 states had been 2 additional states have been joined by 1791, I think. You know, if you want to add in 1868, then obviously you're talking about a much broader a number of states here. But that was one of 2 really interesting things that I think Kavanaugh said. He was also joined by Justice Barrett. At one point, Neil Keitel, you know, he tried to challenge the entire premise of the Bruen test, right? He said, you know, at step 1, you have to look at the history, right, to determine whether or not the Second Amendment is implicated. And Kavanaugh and Barrett both said no, because he said otherwise, you know, virtually any law dealing with a firearm could be challenged. And both Kavanaugh and Barrett said, yeah, that's the point, right?
That's the whole point. And
the Second Amendment, that's the test, right? That's the first step.
Right. It was shocking that the state even wanted to go there to begin with. I'm shocked that they didn't realize they were going to get shot down on that. That is definitely going to be brought up in a majority opinion. It's going to be. The outliers are going to be brought up. You're going to see Bruen strengthened as a result of the opinion in the majority. Again, working on the assumption that we win this hands down, which I believe we will. Yeah. I believe that's a slam dunk. You can put your money on it. It's just what will the score look like, right? But that's going to have to be addressed. And this case has a tremendous ability to strengthen Bruen in those terms. How far outside the bounds of Bruen will they go relative to property? What you will see, no doubt in my mind, in this decision, I'm sure you'll agree with me on this, is that they will be talking about the second class Second Amendment right that is being abridged by the very basis of Hawaii's law. And they brought it up. Several justices on the conservative side brought up the fact that this does not happen to First Amendment. And I forget, I think it was a solicitor who brought it up. Again, forgive me, it may have been one of the justices that said, we don't go into a church and seek permission from the pastor to say certain things. We don't go into a convenience store and say, do I have permission to talk about these subjects while I'm here in your establishment? Can I talk about this while I'm sitting in your restaurant, for example? That will be addressed, and that will also strengthen Bruen along those terms. I am fascinated by this case. I didn't think I would be as fascinated until I heard the arguments. And like I said, I really enjoyed watching Ketanji Brown make an utter fool of herself. And, you know, I just was sitting there the whole time chomping at the bit, just a DEI hire, and we're watching it firsthand right in front of our faces.
Yeah, it was, that was
there for life too, I might add. My gosh.
Yeah, I know. So yeah, we'll see. I mean, we've got, a few months before this decision comes down, we got U.S. versus Hamani, but, I am hopeful at least that beyond Wolford itself and the vampire rule, I really want to see the Supreme Court shoot down this premise. We saw the Fourth Circuit, a quote of the Second Circuit yesterday, that essentially any crowded public space can be deemed sensitive, right? The Supreme Court said in Bruen that New York couldn't make the island of Manhattan a sensitive place simply because it's crowded and is generally protected by the NYPD. But we've seen courts completely ignore that statement and say, yeah, if it's a crowded place, it's open to the public, maybe there are kids there. All right, that's sensitive, right? You can ban guns there. I want to see the court at least address that in terms of the scope of the vampire rule, banning concealed carry in all public places. I hope that they use that as the opportunity to say, that's not the test. It's not whether places are crowded, whether they're protected by police, whether kids might be there. That alone, those things don't alone make a place sensitive. And I don't know we're going to get it, but I hope we do.
Yeah, I think we saw Kavanaugh. I believe it was Kavanaugh again, ask the United States, do you I think you agree with the test laid out in both Heller and in Bruen that there are sensitive places. And then they referred to the two, and the other one being, of course, government buildings, to which the government readily agreed. And I kind of bit my tongue on that and said, well, that's arguable.
She did still say that there needs to be that historical analysis. Right.
And that is true.
And I think that's important. I mean, look, there are going to be some government buildings that'll be deemed sensitive. The idea that every government building, simply because it's owned by the government, is sensitive.
That's it.
I don't think that has any basis in history. Right. But going back to what you talked about with Scalia, the Supreme Court, look, this is a small C conservative court. Right. So they do tend to take baby steps. Right. And so the first step in Heller was acknowledging that the right to keep and bear arms is a real right. Particularly when it comes to keeping a gun in the home. Bruen, it's a real right when it comes to bearing arms in public. But they were always very careful about we don't want to upset the apple cart, right? We don't want to cast doubt on all of these laws. But by necessity, the Bruen test at least requires an analysis to be done on all of these laws, right? And if that test casts doubt, well, so be it. And I think that's that to me was what the government's position was.
Yeah.
And I hope that it's a position that the majority of the court actually accepts too, because I think that is what's required under their own test. They don't by quoting themselves, say, well, government buildings and schools,
To step outside of that, it was pointed out by more than one justice that you could deem, as you just pointed out, any place to be a sensitive place in an effort. And they admitted that would happen. We've seen New York do it. We've seen California do it. It came up in Hawaii. How much of Hawaii land is park?
Right.
How much of Hawaii land is public park, for example? So this, what are they going to do? Deem everything outside individual neighborhoods sensitive places by deeming, but the wrong decision in this case would allow that to happen.
Yeah.
And we've already seen them. And it was mentioned yesterday again by Kavanaugh, who pointed out that states are pushing the boundaries right up to the legal limit. And without mentioning names, he was clearly referring to New York. He was clearly referring to New York City. He was clearly referring to California and Democrat-led states that have been pushing that Bruen test right up to the legal limit. What's to stop them from going even further? If Hawaii is deemed to be right, and if there is nothing, you would literally have a patchwork across the nation. And I don't think SCOTUS is going to allow that to happen. Yeah. I'm sticking with I'm going 8-1, baby. I'm going all in.
All right, you go 8-1. I'll stick with 6-3, and we'll be in the middle on 7-2. But
I'll take it.
Speaking of states that are pushing the boundaries, let's talk about Virginia for just a second.
Oh, what a mess
here. Surprisingly, we have not actually seen a bill to expand the number of gun-free zones in Virginia. At least, and I should knock on wood here because we do have a couple of days left for bills to be filed. But as of yesterday afternoon, which was the last time I looked, nothing expanding gun-free zones, but a whole bunch of other restrictions. We saw our permit to purchase bill introduced. You got the assault firearm ban, ban on magazines over 10 rounds, $500 tax on suppressors. New regulations for people wanting to get a concealed carry license, again, all kinds of stuff. And there's more to come, I'm afraid. So Monday was lobby day, VCDL's lobby day. I was planning on attending. I was not able to make it because I had a plumbing emergency at the house that kept me here. But I saw the pictures, talked to some folks who were there. The good news is attendance was up over what it's been over the past couple of years. I mean, it was maybe a couple of dozen people, maybe 100 people.
Yeah.
I think there were at least 1,000 people, maybe close to 2,000 people there.
Mm-hmm.
Still was not what we saw in 2020 with the 30, 40, 50,000 people just jammed into downtown Richmond. And And I think there may be a couple of reasons for that, but how concerned are you about gun owner? I don't want to call it apathy.
I will.
Okay, I'm not sure it
I'll
is.
call it.
I'm not
Well,
sure
maybe
it is
I'm gonna say
fair.
defeatism.
Defeatism, I think maybe is a
I
better
think,
word.
and here I had a text exchange with Phil Van Cleve prior to us doing the show today.
Mm-hmm.
And I mentioned to him that I rejoined again VCDL. I didn't realize that my membership had actually lapsed, so I went ahead and renewed again. But he responded, "Thanks for being in the fight with us, Mark. We estimate that we had around 2,000 show up at our rally, much more than the antis had at their rally." Okay, good, but not good. Would I like to have had more, and should we have had more? Sure. The people who show up are quality more than quantity. Please help keep your audiences informed of our status. Bills can be watched here at vcdl-lis.org. I'll tell you what concerns me about this. I think you and I talked about it last week. You go back to 2020, it was what, 50,000 people?
I think so. I think that's a fair number.
Massive. And in the face of what Virginia has right now, one of two things I thought was going to occur: a massive turnout equal to or better than years past, or virtually nil. And sadly, 2,000 to me is virtually nil under the circumstances Virginia finds itself in. So what does that tell me? Well, if 100,000 people showed up, it would kind of signal to me, all right, now you're pissed off because why? You didn't vote? Did you vote? You're 40,000 stronger than you were before. You knew this was going to happen. How many of you that turned out to this rally are turning out after the fact because bad things happened because the elections went the wrong way? Number one. On the flip side of that, what does 2,000 tell me when it should have been at least 40,000 under the circumstances that Virginia finds itself in, just to make a statement? Hey, we're here. We're not going away. Come and take it. We're not going to comply, whatever that means. That signifies to me almost an attitude of defeatism. Look, they got us. I'm not wasting my time going. There's nothing we can do about it. And while I understand that, I hate it. I'm not sure what it means overall, but it's certainly, you can draw that inference from the lack of participation. And now 2,000 is good. As Phil pointed out, it's better than the antis, but this ain't a scorecard. They're always going to beat us for the most part, which is why you should be excited when they don't. But they'll have 500,000, 300,000, 500,000, 700,000 people show up in D.C. We won't. We're working. We're busy. We have a Second Amendment. They're the ones fighting against it. I don't know what it means. It shows to me, sadly, I think many Virginians just feel defeated and like there's not a lot I can do about it.
I think that's accurate. I mean, the number of people that I've talked to have said they're looking at moving. I think, is evidence of that. And I think, you look back at 2020, Democrats took control of the state legislature, but it was a very narrow control, right? They had the two seat. I think they had a 2-vote majority in the House, maybe 1 vote in the Senate.
It was 2-1. I can tell you that.
This time, they've got a supermajority in the House of Delegates, right? Senate wasn't up for election last year, so it's still a 2-seat majority for Democrats, but I think that there is that attitude of, okay, we're not gonna be able to stop this stuff this time around. Democrats are marching in lockstep. We've not seen any dissent, in terms of the vote to redistrict Republicans out of Congress, right? Go from a map where I think it's a 6-5 to a 10-1 Democrats. They're showing party discipline right now. And if they do that with gun control, then all of these bills pass to get to Governor Spanberger. She's already going to sign them. Gun sales are booming in Virginia, right? I mean, I can tell you that, right? So maybe the passive resistance is going on, but even at the local level, Mark, I mean, to speak to that defeatism, it would be one thing if they stayed away from Richmond, but they were showing up at their county supervisors meetings and demanding the Second Amendment sanctuary status. We're seeing that in a couple of counties. City of Lynchburg getting ready to vote on a Second Amendment sanctuary resolution to reaffirm its status. Campbell County, I think, is getting ready to do the same. There might be one others. I talked to an individual who lives in Fluvanna County. He had spoken to his sheriff, and sheriff thinks they might be able to get it passed by the Board of Supervisors, but things will be close, like 3-2. But other than that, I mean, we're not seeing that, that Second Amendment sanctuary movement sweep across the state like wildfire like it did 6 years ago. So it's not that they're just disengaged in Richmond. I think that they are disengaged to a large degree. At least a lot of gun owners are disengaged at the local level. And that's disappointing and upsetting and concerning to me, because that, to me, is where we are able to show some resistance, not to every piece of legislation, but to some of these, possessory gun ban bills and
Well,
bills. This is where the Second Amendment sanctuary can make a difference.
That is the very definition of defeatism right there. That's it. You just pointed it out. Here's what I find interesting about that. And I know a lot of people in Virginia, as you know, my history in the state over many years. I have a lot of friends, and I still have family in Virginia and graduated college there and all that, lived in many cities across the state over the years. I have very close friends of mine who have said, I've tuned it out, Mark, I'm done. I have my guns. I will buy whatever I want. I will bring whatever I want to my home. I've tuned these people out. I am not paying attention to their laws, period. And I think that's what you're going to see. A lot of people have said, look, it doesn't help for me to take time off work or do whatever I have to do. I can't vote my way out of this now. There's a supermajority. And you're right. Those two in the Senate are not going to flip. They're going to move in lockstep with that governor, or they're going to pay political consequences, particularly if there's redistricting done. Okay. So, and they know that they're going to move on gun control. It is inevitable. It is going to happen as we predicted it. And I think a lot of residents of Virginia right now are saying, you know what? The red line has been drawn. The decision that I never thought I'd have to make as a free Virginian, I now have to make. And that's it. I'm done. Those laws don't matter to me anymore. I'm going to live my life, the government off my back. I'm not even going to watch the news. And I think many, many Virginians have gotten to that point. And this is what happens, ladies and gentlemen. When the Democrats get their way, you're forced to make decisions you never thought you'd have to make. And Virginia's there. Do I comply with these laws or not? I'm just going to shut my trap, tune it out. I don't care what they say, and I'm going to live my life. And I hope that happens. Well, I don't know.
Time will tell. All right, Mark, man. I appreciate you joining me on the program. It's always great talking to you. And I'll be joining you on the Daily Defense this afternoon as well.
Yes, you will. And I'm so glad that you're not at SHOT with me, not at SHOT. We'll have a great time on the program today for sure.
Yeah, this has been a challenging week. I'm sorry I'm in Vegas. Okay, I should have known better. But yes, glad that you're safe at home. I'm safe at home. And we'll chat again this afternoon. Make sure you check out the Daily Defense and, of course, the Big Monster Cast, Armed American Radio, Sunday nights. Mark Walters, thank you so much, sir. We'll do this again very soon.
Thank you, brother. I love you. Thanks, everybody. Have a great day. Stay safe out there.
And thanks to Mark for joining us on the program. Looking forward to seeing him again very soon, and looking forward to hanging out with him a little bit this afternoon on the Daily Defense. All right, before we get to today's Armed Citizen story, our good deed of the day, and our recidivist report, let's talk about this for a second. From city streets to mountain trails, your gear should go wherever life takes you. That's why at Modern Rugged Leather, every bag, including this one, handcrafted from premium, responsibly sourced leather. It's designed to look sharp, last long, and tell a story all its own. Every stitch, every buckle, every strap reflects timeless craftsmanship and is backed by a lifetime warranty, because quality shouldn't quit when the adventure begins. So whether it's the boardroom or the back rows, Modern Rugged Leather helps you carry confidence every step of the way. Modern Rugged Leather, modern style, timeless durability, backed for life. Life takes you places. Make sure your gear keeps up. Shop the full collection and find yours today at modernrugged.com. Again, that's modernrugged.com. All right, let's turn our attention now to today's Armed Citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Florida where a repeat offender allegedly killed 3 tourists after a run of violence. Quite the lengthy criminal history, including one previous attempted first-degree murder charge and aggravated battery after he allegedly shot at a person in random vehicles in a Kissimmee gas station parking lot. But 29-year-old Ahmad Jihad Bohe was found not guilty by reason of insanity in that case, which again begs the question, why was he out on the streets now? Florida Attorney General James Uthmeyer talked about Bowe's prior case in a statement after his most recent arrest, again accused of killing 3 individuals, criticizing how the prosecution was handled at the time. He said prior to State Attorney Worrell's suspension, Ahmad Jihad Bowe was acquitted of attempted first-degree murder with a firearm and aggravated battery. It appears she didn't put up a fight to Baja's use of the insanity defense, and he was allowed to go free. Meanwhile, Osceola County Sheriff Christopher Blackman described Bowe as a, quote, frequent flyer with his agency, as well as a, quote, threat to the neighborhood all the time, citing repeated calls for service regarding the suspect. He is accused of fatally shooting 3 men outside of a rental property last Saturday afternoon in what the sheriff called a, quote, horrific and senseless act of random violence. Said it was cold-blooded, it was premeditated, absolutely no issues. There was no conflict between these people. This was just random. And this just happened to be the person who lived next door. So, again, why was Bohé... Now, you can argue, again, maybe the state attorney did not fight hard enough to deprive Bohé of that insanity defense. But I think a more important question is, after he was deemed not guilty by reason of insanity, why was he not confined to a mental institution? Or was he confined to a mental institution? And if so, under what circumstances was he let loose? Because pretty clearly there are still some issues with Mr. Bohé. And he may very well plead insanity once again to the most recent charges of cold-blooded murder. So again, these issues don't just happen in blue states, sadly. They happen in every state of the union, and it's, again, why we have to be constantly looking at ways to ensure that justice is done, as opposed to, cracking down on the fundamental civil right to keep and bear arms. On to today's armed citizen story from North Carolina, where details have been released after two brothers were shot in self-defense at a restaurant called Mac's Speed Shop. I had seen the headlines for this defensive gun use a couple days ago, but there really was not a lot of information that had been detailed at that point. So this happened back on January the 3rd. 45-year-old Daniel Nakamoto, 43-year-old Timothy Nakamoto were shot and killed at Mac's Speed Shop in Fayetteville, North Carolina. According to Todd Joyce, who's the assistant police chief there in Fayetteville, the incident started with an argument inside the restaurant that then escalated into a physical fight. Joyce said that the conflict arose over someone's misinterpretation of apparel, talking about motorcycle club-related clothing. Investigators looked at surveillance video from inside the restaurant. They determined that the individual who fired his weapon did so in self-defense. According to Fayetteville police, the armed citizen later identified as an active duty soldier at Fort Bragg who suffered a concussion during the fight. The assistant police chief called this a tragedy that did not have to occur. He said any loss of life is something that weighs heavy on our city, on our department. And he said he met with the Nakamoto family before releasing additional details about the case, saying, it's difficult when you have to bring in an entire family the day after their funerals and share that information with them. He said, but these individuals were well known in their communities and it was important to provide context. So, again, still don't have a great deal of detail, other than it appears that the Nakamoto brothers were the initial aggressors in this incident, and that the soldier was the victim in this case, and again acted in lawful self-defense in protecting his life after he was injured in this assault. Finally today, our good deed of the day, in the right place, in the right time, willing and able to do the right thing. From CBS News, a cook at Texas Roadhouse, who rescued a couple from a car wreck, just got a scholarship to help him achieve his dreams of becoming an EMT. 19-year-old Juan Mendoza was not at work when this happened. He was driving with his girlfriend. It was a rainy afternoon in South Texas. He noticed a car spin out, and then it stopped in the middle of the highway after a collision. And he said, without thinking, he just jumped into action. He said, my first thought is they could have kids. He said, I have little brothers. He said, and that thought came into me rushing, and I'm like, I'm going to get them out. Juan Omada, who will be 80 this month, was on his way home from a doctor's appointment with his wife, Adriana. Their car was struck. They ended up, spinning again in the roadway. And he said, nobody stopped. He said Mendoza was the only one who stopped. Adriana Omada said he was there at the right moment we needed him. And that's why I say he was my angel. Video of the accident shows Mendoza running in the middle of the road, moving debris away to help pull the Omadas out of their car, which was smoking at the time. And then he went on his way. He didn't give him his name. He just got back in his car and drove on. So they reached out to local media, and CBS News contributor David Begnot was able to track down Mendoza and bring him together with the Omadas at the Texas Roadhouse where Mendoza works. A gentleman named Justin Back, who is president of Acadian Ambulance Service, was on hand as well to offer Mendoza an opportunity to become an EMS worker. He said, we're always looking for people, good people who want to help others. He said, but it takes a big heart. Also takes a lot of intelligence and a lot of courage to do it, a lot of toughness. He says it's a rare combination. But he offered Mendoza a scholarship to become an EMT as well as a conditional job offer once he graduates from those classes. And Mayor Adrian Gonzalez of Velasco, Texas, also presented Mendoza with an official proclamation of Juan Mendoza Day. It's pretty cool. He said, thanks for everything you did. Thanks for being their guardian angel. Juan Mendoza ultimately attributes his character to his parents. He said, they teach me to be humble and to help anybody. And he said the O'Matas needed help. So I know that Juan Mendoza's parents are proud of him. But it sounds like the community is grateful for him as well. And in the right place at the right time, willing able to do the right thing to help those in need. Juan Mendoza, we thank you for your very, very good deed. All right, that's going to do it for this edition of Bearing Arms Cam Company. Please do check out BearingArms.com, though, throughout the day. We're keeping you up to date on all of the latest Second Amendment news and information from all across the nation. Tomorrow on the program, we're going to be talking with Jim Wallace from the Gun Owners Action League. And Jim, by the way, also on the NRA Board of Directors, and that's kind of where the focus is going to be on tomorrow's program. We're not really going to be talking much about Massachusetts. I'll probably ask a couple of questions, but there are some changes coming to the NRA's bylaws, and you can be a part of this process if you're an NRA member. So we're going to delve into that with Jim Wallace on tomorrow's program. Enjoy the rest of your Hump Day Wednesday. We will see you back here tomorrow. By the way, if you, like Mark and I, are in the path of this wicked winter weather that's coming over the weekend, get ready, get prepared, because it really could be awful. I'm going to be joining Mark on the Daily Defense, but I'm going to be in my car this afternoon because I got to drive over to Costco and pick up some supplies because I am anticipating being without power for several days. We got 11 inches of snow back in 2022. It was about 11, maybe it was 15 inches of snow. We're out without power for 5 days. They're talking about 20 inches of snow in Farmville now. So, yeah, we'll talk about next week's programming on tomorrow's Bearing Arms Cam Company. But again, it looks like this system is going to be no joke. So be well, be safe, and prepared. And again, be free.